Not everybody has my cell phone number, but the people that do have my cell phone number have it because I'm always looking forward to talking to them. One of those people is Tammy. Tammy and I have been friends for years. She's also an attorney. We've been friends outside practice as well. But she called me one day and we caught up a little bit. And then she said, look, the reason I'm calling is not just to catch up, not just to talk, but I also wanted to let you know that I'm going to make a referral to you. I know somebody that needs estate planning. I said, great. Tell me about it. And she said, well, she's just been through a big life transition and she's just lost 200 pounds, 200 ugly pounds, and it's a big deal for her. And she wants to continue to get her life in order. I said, all right, great. And Tammy said, you know what I mean, of course. And I said, of course I do, because Tammy's a divorce attorney and she does all kinds of family law, but in particular, she was referring a divorce client over to me because this lady had just gotten divorced from her husband. And to her, it was the loss of 200 ugly pounds that she was grateful to be rid of. That's not always the case with divorce, but always the case with the divorce is that it's a major life change. So in this episode, we're going to talk about how divorce can affect your estate planning, and based on a divorce, some things you might want to keep in mind as you turn your attention from the divorce back to being now divorced and making sure that you've got all your ducks in a row. My name is Jim Miskell. You have found Let's Talk Estate Planning, which is the podcast dedicated to the proposition that if people have their estate planning in order, families will have a roadmap when grief, crisis, and transition strikes, and they won't be left trying to figure out a bunch of administrative tasks, but rather they'll be able to concentrate on what's important, and that's supporting one another. I want to let you know before we begin that this is a podcast. This is not a legal consultation. Legal consultation occurs when you hire an attorney, and it's a one-on-one meeting with that attorney where you get to tell them everything that's important to you, and they get to ask questions to figure out what's important to them, or more importantly, to the law, so that they can give you good advice based on your specific situation. Legal advice doesn't come from podcasts. It doesn't come from social media. It doesn't come from Google. Sorry, Mr. Google, but that is not a legal consultation. So keep in mind that the podcast, although my intent is to give you good information about estate planning so that you'll be able to move forward and make some decisions about where your planning should be, that the podcast itself is for informational and educational, hopefully a little bit of entertainment in there, purposes. And that's my disclaimer. So there you go. What is important in estate planning is making sure that it fits what's going on in your life and your family. And as I meet with clients, the first part of the process is always to review what they may have in place. Estate planning documents don't expire. They don't have a best by date or a shelf life date where they're no longer good. But what can often happen is that circumstances, whether that's within the family or it's assets or it's legal changes or a move, cause those documents to fall out of sync with what's going on in my clients' lives. This is never more true than in the case of divorce. So with estate planning, one of the goals is to make sure that things go the way you want them to. Nobody has to benefit from your estate other than the people you choose. But the reason that a divorce is significant is that it affects who your heirs are. Now, heirs, and we've talked about this in other episodes, but heirs are the people who inherit from you if you don't have a valid will. And that's determined by the code in whatever state you reside in. I practice only in Georgia. And so for me, that's the state code of Georgia, which dictates when you die without a will, this is who inherits from you. Those people are important when you have a will also, because those are the people that the probate process requires to get notified of the probate process. I think of them as concentric circles that get larger and larger as you go out. But the first circle in Georgia and most other states are spouse and kids. When you eliminate a spouse through divorce, that throws off who your heirs are. Well, it doesn't throw it off, it just changes it. And as a result, under Georgia law, it invalidates many aspects of estate planning. Anything that deals with the spouse, anything that involves notifying heirs is now a whole different picture. And the whole reason you get divorced is to be divorced, not to be together anymore. So post-divorce is a great time, well, it's an imperative time, to review your estate planning. And this is something that Tammy realized and was advising her clients, but I meet with people all the time who've been through divorces, and because of the haze of what's going on in the divorces, and because divorce attorneys have a lot of clients, and they may mention it to clients and say, hey, don't forget to update your wills, powers of attorney, and all that kind of stuff. But it's very often lost in the haze. So I thought it was important to spend some time talking about it today, so that if you or somebody you know has recently been through a divorce, or maybe it's not so recent, but you haven't done an update of your estate planning, this will give you some information that you can give on to them, or that you can use yourself to make sure that your estate planning matches what you need. I would say that we're just going to sort of walk through some tips and things to keep in mind. When you locate an estate planning attorney that you're going to meet with, part of that initial consultation is always reviewing whatever estate planning is in place. And part of that conversation should include who are your heirs, who gets notified if you've got a will, who's going to get notified of that probate process. If the will is found not to be valid, those are the folks who are going to inherit. That's why they're notified of the probate process. So one of the things, along with current documents, is that divorce agreement. Or actually, what's more important than the agreement itself is the agreement along with the final order of the court, adopting the agreement if an agreement was reached, or if there was a trial, just the final order of the court, the divorce decree that awards property, custody, those sorts of things, because that can impact how you set up your planning. In the judge's order, there may be property divisions and things about that property division that need to be kept in mind as the estate planning is constructed, so that the estate planning doesn't violate what the judge told you to do under the order. Sometimes there are obligations that need to be taken into consideration. So that's number one, is keep that divorce decree in mind and in play as you turn to do your estate planning. So far, we've sort of talked about what happens with a will and who gets your stuff when you die. The other two really important parts, if you have listened to this podcast much at all, you'll know are the durable financial power of attorney and also the healthcare directive or medical power of attorney or power of attorney for healthcare. Those two things, very often you've set up while you're married your spouse to be in the first position. Now, under your state's law, the divorce may eliminate that person from serving. If you've got a backup, okay, you're okay for a minute, but you should probably get that first person off, your ex-spouse off. If you don't have a backup, you now have essentially no document, no planning. But it can vary from state to state in how a divorce affects the appointments of your medical agent and also the appointment of your attorney in fact, your power of attorney agent. So those are important to review. It's very likely if you've gotten a divorce, and I would advise you strongly, if you've gotten a divorce, you probably don't want your ex-spouse as an agent for either one of those roles. Having said that, not every situation is the same. Every family is a little bit different, and I've had clients that several years past divorce, they discovered that their ex-spouse was one of their closest relationships, and I've seen some of my clients include an ex-spouse in that list of trusted agents. Even though they shouldn't have been married, they still trust each other. That is not the case in most situations. However, you can't rule it out. Every situation is different. So far we've talked about how the divorce can affect not only what the will does and the validity of the will as a whole, but also the validity of the appointment of your healthcare agent and also the validity of your power of attorney, who the agent is there. Some powers of attorney say, hey, if there's a divorce or a separation, that person should no longer be my agent for legal and financial things. That makes a lot of sense to me. Your power of attorney may not have been drafted that way. Your state statute may not automatically exclude somebody. It's important to follow up and make sure that the divorce is actually complete, because nobody knows when they're going to have a car accident. Nobody knows when they're going to become ill. None of us get through this alone, and you want to make sure that the helpers you have designated don't include an ex-spouse that you don't want anywhere near it. In Georgia, a marriage can affect the validity of your appointment of non-spouses on your health care directive, and so it's important to make sure that you've got who you want and you make those appointments after the event of a divorce or after the event of a marriage. When you do will planning in Georgia, a marriage or a divorce, because it changes who your heirs are, it changes who gets to inherit if your will's no good, either one can invalidate a will. if the will wasn't made in contemplation of that change. So there's language that your estate planner can include in there if you've got a divorce pending. You want to do some documents in anticipation of it. You don't necessarily have to wait till after the divorce decree is final to get something in place. And I've had folks that do that. We'll do sort of a Band-Aid during the period of the divorce. We'll make sure that we're very careful not to violate any standing orders of the divorce courts. What do I mean by that? I mean that there's generally a standing restraining order that when a divorce gets filed, there are a lot of things you shouldn't be doing, moving finances around, hiding it. Basically, the judges don't want you to hide assets, right? Estate planning is not necessarily off the table. You just want to make sure that you comply with what the standing order is. The other thing that may be as important as complying with the letter of that standing order is the impression that you're creating with your divorce, with the judge who's hearing the divorce. Your divorce judge, I was about to say. They wouldn't want to be thought of as that way, but the judge who's hearing your divorce. The impression that can be created if you're doing a lot of moving things around may loom in the decisions that they make. So very often I counsel people, let's just stand pat for a second. Sometimes it's important to go ahead and get new power of attorney agents, new healthcare agents in place, but we might hold off on the will, the distribution of property, or creating a new trust. So it's important that even if you're doing things that are substantively fine, you don't create an impression that you're doing something shifty. The best person to consult with about whether or not it's appropriate to make changes like this is not really the estate planning attorney. They're the best professional to consult about what the change is, how to do the changes that you want. The best person to consult about whether or not it's a good time to do them is the divorce attorney. Whoever your family law attorney is that's handling that process for you will tell you whether it's smart to go ahead and do those things now or later. And very often for those family law attorneys, it's a balancing act between protection of your position, what's important for your kids and what's important to you, and also what they're trying to accomplish through that divorce process, getting the case through the process. And so they can weigh those things and talk them through with you before you make a decision. I guess what I'm saying is I don't want anybody running out in the middle of a divorce to go do a bunch of things without talking to your family law attorney first. Let them help you navigate through it without making a bunch of decisions that you might be sorry for later. Even though you're not up to no good, you don't want to create an impression in the judge that you're doing something, again, that's shady or shifty. So who gets your stuff when you die is important. That's the will and the trust. There's another way, well, there are several, but another way that property gets distributed upon your death is through beneficiary designations, transfer on death, payable on death designations. Those appear, of course, on retirement accounts, IRAs, 401ks, those sorts of things, and also can be on regular investment accounts and, of course, insurance policies and things like that. The fact of your divorce may not affect at all, and in fact likely does not affect the beneficiary designation that you've made on any of those accounts. Meaning that you can get divorced. You can change your will, you can change your trust, take care of all those things. Make sure you've got new people on your power of attorney. Make sure you've got new people on your healthcare directive. And then if something happens to you, you get run over by a Mack truck and you're killed, when it comes time to distribute the IRAs, the 401ks, anything with a beneficiary designation, if that's not updated, it doesn't matter that a divorce has happened. There was a woman where I went to church several years ago whose husband of 15 years had passed away pretty suddenly. He had had a pretty toxic divorce and relationship before that marriage with the woman that I knew. When he died, it was very sad because it turned out that he had not gone back to his retirement accounts and his insurance policies and reset them since the divorce had happened to the first spouse. So this woman that he hadn't been married to for more than 15 years ended up getting a significant part of what he had worked so hard to save. And it was a shame because he really was dedicated to this woman, his second wife, and she was in a tight spot and had to make some hard financial decisions. So not only is it important to think about the estate planning documents, but also the beneficiary designations, how things are set up on the payable on death, transfer on death, those sorts of things. Hey, Jim Miskell here. Sorry to interrupt the episode. Hope you're enjoying today's content. A lot of times when folks are thinking about this kind of thing, questions spring to mind. If you have questions, we like to do some question and answer episodes. So you can go to our website, letstalkestatesplanning.com, and shoot us a message and say, hey, on the podcast, I'd like Jim to cover this on the next question and answer session. Or if it's hitting closer home, especially if you're a Georgia resident, of course, we can't give legal advice on the podcast because it's not specific for your situation. But if you got a situation that you need to handle, it's important to get that done. So letstalkestateplanning.com is how to contact the office. I'd love to talk with you about the specifics of your situation and make sure your estate plan is everything that your family should have it be. In the meantime, we're going to go back to the episode. Thanks for tuning in, and I hope to talk to you soon. So for legal and financial matters, you want to make sure that you've got a good power of attorney that's fresh, that doesn't have your ex-spouse on it, makes it very clear who those people should be that are involved in legal and financial decisions for you post-divorce. With your healthcare directive, you want a new, fresh slate of folks there that doesn't include your now ex-spouse. With your will and trust, you want to make sure that your executor and trustee list, again, fresh. You don't have your ex-spouse on there. Also, the distributions of property probably change a lot. Very often, I would say most of my married clients, it's all to each other, all to the survivor. Sort of, a lot of folks describe that as a sweetheart will or a sweetheart trust that says, everything to my surviving spouse. And then when we're both gone, to the kids, if we have kids. After divorce, you want to readjust that, of course. We've talked about how not only do you need to address that in your wills and trusts, but also in your beneficiary designations and payable and transfer on death accounts. The next thing to think about is custody of the kids. So if there are minor children involved, you're going to want to make sure that you make guardianship designations in your will and also your power of attorney. I think it's important to make guardianship designations not just in the will, but also in the power of attorney, because in the event of disability, you may still be alive but not able to take care of the kids, and you want some say in who the guardians are going to be. What do I mean there? I mean, if it comes to a point that a judge is getting ready to appoint guardians, they will give strong deference to the parents' nominations of who should be the guardians. And you have full reign to decide who's going to be trustees for the kids after you die. There's no issue there. But as far as appointment of guardians, you've got a strong say there. Now, as long as there is a parent alive that still has custodial rights, so a lot of divorces end with both parents having custodial rights. It's pretty rare, in fact, for custodial rights to be terminated for somebody, parental rights altogether to be terminated. And so whether that's a joint custody situation or more of a standard visitation kind of thing and every other weekend, that hasn't actually terminated either parent's rights as a parent. And in the event of one parent's death, the surviving parent is going to have sole legal and physical custody of the children. So it's important to have a list of guardians if something happens to both of you. This is an issue where if you can come to an agreement with the ex-spouse, it's beneficial. What I have found is that families will follow what the directives are as far as who should be guardians. If there's not a clear direction, for example, if you and an ex-spouse are both killed or both disabled, and you nominate different people to be guardians for the kids, you've still got a proxy battle going on for the kids. If you can come to an agreement, that's great. If you can't, do the best you can to nominate the folks that you think should have custody of the kids. Maybe your spouse won't think of it or get around to it, and then your list will govern in any event anyway. But it is important to keep in mind that that list of guardians that you appoint in your power of attorney in case you become disabled, in your will in the event of your death, those only come into play after both parents are no longer able to parent. So just to keep in mind, another thing to look at as far as making sure you update. Very often in divorces, you don't want any part of your ex's family at all. You may have a sister-in-law or a brother-in-law that you have appointed and you're really comfortable before the divorce, but you learned a lot during the divorce and you think they shouldn't be raising the kids either, and you want to get those people out of there. So do the best you can to come up with a joint list if you can, if it's just not possible. Just, again, do the best you can to come up with a list that's appropriate, who you think the best folks can be. On situations where there are parents that are unable to parent because they're disabled or they're deceased, courts are looking for guidance. Courts really would like to effectuate the wishes of the parents. So don't leave, if you can't agree with your spouse about who this list should be, don't remain silent on it. List who you think it should be. Give the court who might be making these decisions some indication of who it should be. So there you go. After divorce, you want to take care of the estate planning documents. Those are your powers of attorney, healthcare directives, wills, and trusts. You want to make sure that your beneficiary designations and ownership accounts are consistent with your post-divorce life, and also that you've got a list of guardians for the kids. And yeah, I said list. You shouldn't just have one. You should have some backups there. List of guardians for the kids in case both parents are out of the picture and not able to raise the kids. After you've been divorced for a while, you may be thinking about marriage again. I find that many of my clients who have been through the experience of a divorce, if they're considering remarriage, they're thinking about a prenuptial or an antenuptial agreement. And the prenuptial agreement lays out the division of property upon death or upon divorce of a couple. And it's just making some clear decisions and setting some expectations. It can be a really good and useful idea. And as we know, only love is in mind if the Massey is signed. That's what I learned from the Coen brothers and George Clooney. If you got a good prenup, all the focus is on love and not the property. Having said that, if you pull the appellate cases in Georgia on prenup agreements, they break about evenly between agreements being upheld and agreements being tossed out by the court. This is not to say it's not worth doing a prenuptial agreement. It just is an observation that when it goes to the appellate courts, they break about evenly. So it's not a lock. The law in Georgia, and I imagine in most other states, has been pretty stable on prenuptial agreements in Georgia since about 1982. Everybody knows what it takes to have a valid prenup. Despite that, there's still these cases in the appellate situation where they end up being found not to be valid, which is why even if a prenup may not be 100% lock, 100% solid, it is valuable to set expectations. And it also sets a very clear expectation about how the parties to the marriage think property should be treated. I would suggest that the next best step after doing a prenup agreement and getting married would be coming in to do some estate planning. Why? Because you can set up some trust planning that mirrors what the prenup agreement says. And if it's in the trust planning, if it's in the estate planning, that's what's going to occur. And nobody ever has to take it to a judge to say, this is the prenup agreement, we need this enforced. And a judge doesn't have to make a ruling. And they never end up in appellate court. So the best way to ensure that the intent of the prenup is effectuated is making sure that you've got estate planning that backs it up, that follows it. In my office, Joanne, who I've worked with for many years, I'm very fortunate, she said that, that's the prenup's like the promise, and the delivery on the promise is the estate plan. And I think she's really onto something there. So what I wanted you to be aware of here today in this episode, I don't want to belabor it too much, is that the marriage changes who your heirs are. And divorce does the same thing. It takes somebody out of that picture. The will, the power of attorney, the healthcare directive can all be eroded by divorce. And even if you got some backups, it may call into question some other provisions of those documents. So it's important to renew those documents post-divorce. Along with that, don't forget your beneficiary designations, your ownerships, your TODs, your insurance policies, those sorts of things. And if you're turning around after a divorce to get married again, consider having a good conversation with your spouse to be ahead of time. How should things happen in the event of either one of our death or divorce? And that's what a prenup is all about. Following the prenup should be estate planning, making sure that you as a couple have put in a plan that's consistent with what your wishes are. Families will follow what you want if you write it down. They're not psychic. And kids and stepkids will go along with what parents have decided if it's pretty clear. And that's been my strong experience over 33 years as an attorney, is that families want to do what you want, but if you leave them guessing, it's much more likely that fights can break out. So if this episode has given you some ideas, just whetted your appetite, and you have questions, I would invite you to come to, if you're in Georgia, come to a live workshop. I do workshops at least twice a month on all aspects of estate planning, and we can answer some questions there. If you're a Georgia resident, you want to consult about your particular situation, that would be legal advice. If you want to come get legal advice, you can go to our website, letstalkestateplanning.com. Not only will you find a way to make an appointment there to find more information about estate planning topics, but also to register for our workshop. We would love to see you there. Not only do we do live workshops every month, we also have recorded workshops and very often do live webinars as well. So there's a lot of ways to get information. There are many episodes of the podcast, Let's Talk Estate Planning, covering all sorts of aspects of estate planning, and we're cranking out more all the time. If you have questions, you'd like to see a future episode cover a particular topic, let us know, and we'll try and get it in there. We're going to do a question and answer episode coming up, and we'll do those from time to time. My name's Jim Miskell. I've been an attorney practicing estate planning in the state of Georgia exclusively for about 15 years, and been an attorney here in Georgia for more than 30 years. So I've learned a lot talking to people, and the whole point of this podcast is making sure that people have the information they need to begin making the decisions to put some estate planning in place so that your family isn't hunting around in the dark when transitions occur, that they know what to do. Thanks for your time. I really appreciate you joining us. Look out for episodes to come, and hope to see you soon. Take care.